I had a family come and meet with me whose parent had passed, and they did have a will. Their parent ended up executing their own will, meaning they did this online, and then they signed the document. But it was not prepared in the correct manner. Or it wasn't prepared in the correct manner because there was some ambiguity in there, but it wasn't signed in the right way to make it a valid will. Hello and welcome to Navigating Estate Planning with Caress Law. I am Tammi Caress, your host today and founder of Caress Law, where we help clients with all their estate planning and probate needs in Oregon and Washington State. Today, I'm talking about the exciting process of signing your last will and testament. And now it's time for the disclaimer. The information contained in this podcast and associated material is intended to furnish listeners and users with general information on matters that they may find to be of interest. The information in this podcast provided by Caress Law and its agents are for general guidance and is not intended to replace or serve as a substitute for any advisory, tax, estate planning, or other professional or legal advice, consultation, or service. Sometimes we may reference third-party materials or websites. Such links or references are only for the convenience of the listener, user, or browser. Caress Law and its agents do not recommend or endorse the content of third-party information or sites. You should consult with appropriate Caress Law professionals or other professional advisors for advice concerning specific tax, estate planning, or other matters before making any decision. In summary, this podcast is not legal advice. If you need legal advice or before acting or making any decision with anything talked about in the podcast, seek the counsel of an attorney. Thanks so much. I have talked in the past in prior episodes about what happens when a person dies without a will. If you want to learn more about that, you can go back and look at one of those episodes, and I'll drop that episode in the show notes below if you want to listen to it. But for today, what happens when a person dies without a will is we look to state law. State law will have a statute that determines who inherits from you when there is no will. And state law usually follows family lineage. And in this scenario, the family lineage would have been the children because this person died without a spouse. And unfortunately, he didn't name all the children in the will. And the reason is that he had a child out of wedlock that he didn't know about until he was much older. So he didn't learn this information until he was older, and then never had a relationship with this child. And under state law, if his will is not valid, that child will also be involved and included in the inheritance under state law if he died without a will. So he has this will, he's naming the children that he did know as the beneficiaries, and those children are now here because they want to probate the will. Well, because it wasn't signed in the right way, it's not valid. Now, there are steps we can go through to try to get the court to honor the wishes of the testator. However, those are some big hoops we have to go through. So what I recommend here is in this scenario is we would have all of the children who would inherit if the will is valid, and those who would also inherit if the will was not valid agree that they think this is a valid will. So now we had to go and talk to this daughter who was not listed in the will, did not have a relationship with this guy, with her dad. And now we have to say, hey, will you consent to this? That's awkward, right? Well, that's what we need to do. And when we do that, we would have to have everyone consent. Then we would submit it to the court showing all of the heirs and beneficiaries consent. And then the court will determine from that point whether it will accept the will as is, although it wasn't signed in the right way, or the court can say, I'm sorry, even though you have everyone's consent, we're still not going to declare this to be a valid will. So this whole process could have been avoided had he just signed his will correctly. And it took a lot of time and it took a lot of resources from the estate. And those resources would normally go to the beneficiaries, but now they're not. It took a lot of time and resources, and we had to jump through a lot of hoops, all because it wasn't signed in the right way. I see this come up so often in my practice where a person has passed and the will that they signed was not signed in accordance with the formalities required to make that will a valid will. It actually came up in my practice this week. More and more of us are becoming mobile, or working from home, or we're working at the beach, or wherever place you may be. And signing your documents in front of your lawyer may not be realistic for you. And as we move on in time, I think this will become a more and more common to sign your documents outside of your lawyer's office. So that's why I decided to address this topic, because it's just important, and I think it's a reality for many of us today. While you are listening, please keep in mind that I am really focusing on the will execution requirements that I know in the jurisdiction that I practice in. And it is extremely important that you understand the will execution requirements in the jurisdiction that you live in. Now, many of these requirements are very similar across the states, but there are some nuances, so please keep that in mind when you're listening to today's episode. Another quick story that I had is a client who, well, he wasn't a client. His family was a client. Another person who died, and he actually had a handwritten will, did not sign it in the right way, just told all of his family what he wanted, wrote it out with his family present, signed it. He was on his last days, and he was remarried. He was in a second marriage. And of course, all the family was in agreement that this was going to happen, which, by the way, it's great that they were all in agreement, but doesn't necessarily mean that his wishes will be followed, because he did not execute this document in the right way. Well, and sadly, what ended up happening, because it was a blended family, the inheritance and who inherited what and how much is different under state law with a person who died without a will and versus the will that this person wrote. So once he passed, the family could not agree. They would not all consent to this will being valid, and it put the spouse in a terrible position, the new spouse. And I say new, but the spouse was a spouse of 30 years. So not that new, they didn't have kids together. So it caused a lot of problems. The spouse ended up being in a very terrible position, having to move from a home that she'd been in her whole marriage life. And it was awful. It was awful. All could have been avoided had he had a professional prepare his will, and B, it was signed in the right way. So I hope this never happens to you. And that's why I think this episode is so important. If you don't follow the will execution formalities, you don't know that your will be valid. You don't know that your intent will be followed and carried out. And you're essentially just putting it into someone else's hands. And when you do that, it most likely or oftentimes will cause chaos, mistrust amongst family members, and really break up those family relationships and those family bonds. That's why this is so important. Okay, now that I shared with you a few war stories here, I'm going to get to the requirements of signing a will. They're pretty simple when I lay it out in this way. Just remember that we are focusing on Oregon here. So again, look at your own state requirements when you're signing a will outside of your attorney's office. But we need the testator, the person who created this document, the person who's making their last wishes, making their last will and testament. So they should sign their will in the presence of 2 witnesses. And I'm going to go a step further and say those 2 witnesses should be disinterested, meaning they are not named in the will anywhere. Okay, so 2 disinterested witnesses shall see the testator sign the will, and those 2 witnesses shall attest the will by signing it as well. Okay, pretty simple, right? I am going to go a step further. Many jurisdictions used to require witnesses when the testator died to go into court to confirm under oath that they witnessed the testator sign the will, and that is the testator's signature on the document. The testator was over 18, was of sound mind, there's no undue influence. That's extremely inconvenient to be hauled into court because you witnessed a will signing. So now what we do is best practice is to have the witnesses sign an affidavit in front of a notary. So not only the witnesses are signing the will themselves, but they're also signing another document called an affidavit in front of a notary. And this affidavit takes the place of the witness having to come into court and declare under oath that they were a witness to this signing. So basically we need 4 people to sign a will: the testator, the 2 witnesses, and a notary. And the witnesses are signing the will plus an affidavit. Okay. Now, I will admit what I just told you is not exactly the statutes in Oregon, but it is best practice. And if you follow that, then your will should be a proper will signed in Oregon and probably accepted in jurisdictions outside of the state of Oregon. So there are a few nuances beyond what I just described, but what I just described to you is generally for the normal or the routine population, that is what they are going to follow. There are instances that I have clients that come and say, I can't sign my name anymore. Maybe they have a condition where it's really hard for them to sign. That's okay. The witness's job is to witness the signature, and it doesn't matter if that signature is a smiley face or a check mark. As long as the witnesses are witnessing that signature, they know this person is of sound mind, over age of 18, no undue influence. It doesn't matter if that signature is a smiley face, okay? So don't let a condition prevent you from signing your document. Also, sometimes if you have a condition for whatever reason that you can't even do what I just described, then the testator can direct a person to sign the will for them. Again, this still has to be in the presence of witnesses with all the other requirements I described earlier, but that is okay. I have had this happen so many times where clients have said, I can't even sign my name or something like that, and it doesn't matter. There are rules in place that will allow a will to still be signed, okay? I'm going to talk really quick about e-signatures. I get a question all the time. Just send the document to me and I'll e-sign it. That is, in most jurisdictions, we can't do e-signatures for wills. Now, some jurisdictions, the state of Washington is one of them, are now allowing e-signatures, but they still have the same or similar for execution requirements, the witness presence and so forth, the witness attestation. So some jurisdictions are moving into that direction where e-signatures are allowed. I do think in the day and age that we're living in, that more and more are going to have e-signatures available for wills. But again, there are still formalities that need to be followed even with e-signatures. Super important. So just keep that to the top of your mind. And listen, the best thing that you can do is have your will prepared by a professional, and a professional who practices in estate planning, please. I say that all the time because if someone comes to me and says, hey, I was in a car accident, will you defend me? My answer is going to be no. You do not want me defending you because that is not what I do. I practice in estate planning, and I wouldn't have the first idea of how to defend this lawsuit for you. No, please speak with an estate planning attorney when you're preparing your documents. They will ensure that your wishes are written down clearly for those who are left behind, and they will also ensure that they are signed in the proper way to be valid. Okay, that's my 2 cents for today. Thanks so much for listening, and until next time,